Good evening, everyone. Just when you think it's safe to go back to Twitter after the weekend, there's a new court filing in the ongoing saga to get Richard Allen's proper attorneys back. So we're going to read this document. It's 21 pages. I'm going to get straight into it because I want to keep these live streams under an hour and a half so that they're watchable, because people get really put off by long lives, and I don't want people missing information that is crucial to the justice process for Abby and Libby. So I'm just going to give it a couple of minutes before I start reading and say a few hellos, just to give people a chance to hop on, because this was very short notice. I gave you 10 minutes notice to get in here. Hi, Jean, Laura, Coronating Denmark. Sorry, I don't know what. Hedgy Mum. Who else have we got? Neela, Lil from Vancouver. Not Vancouver, Canada. Vancouver, USA. Tracy, Juju, Sharon, Lucky Lulu, Lucky Lou, Coco 2, Sunshine, Tracy, and Missing Unsolved Crime. And we've also got dashing in there with a 1999 super sticker. Thank you so much, Krista. That's very kind of you. Thank you, thank you. Very early on in the live stream there. Who else have we got? Journey Takes a Trip, Tracy, Andy, Mike, Laurie, Bug Love, Mama Bear, Little Buttercup, Lindsay, Tara, Nelly. Okay. Yeah, I think it's come out in the last hour. I just hopped on Twitter about half an hour ago, and people were posting links to it. So here we are, yet another filing. And this is to the Supreme Court of Indiana. So this is another writ that is going to the Supreme Court of Indiana, with Richard Allen as the relator or realtor. Yes, you are just in time, Stephen. You are just in time. We're just starting. We're just getting going. Okay. All right. So Richard Allen is the realtor, and the respondents, so the people who it's about, are the Carroll County Circuit Court and the Honourable, not sure she's terribly honourable at the moment, but anyway, Francis C. Gull, Special Judge. And this is the brief in support of petition for writ of mandamus. You just read through it, CW. Now, I haven't read it. I haven't read it yet. I turned to the very back page to the conclusion, but I haven't actually read the document. I thought I might as well come on and read it live. So this is Mark Lehman and Cara Wernicke. I do apologise if I'm saying Cara's name wrong. So these are the temporary attorneys acting on behalf of Richard Allen just for this particular issue, to get this writ that's already been filed, and now this new thing, to the Supreme Court of Indiana. So the last thing I reported on in relation to court filings was on Friday, when Judge Francis Gull had to appoint an attorney and had asked the Supreme Court for an extension of 5 business days because she'd only just managed to get an attorney because the Attorney General had declined to represent her. So that was the last thing. But it's not the last time I talked about Delphi. If you watch my video on the Floor of Fire, that's a really, really important one to watch. If you really want to really dig deep and get into the really dark underbelly that is surrounding this whole thing, then I think that's a good one to watch. It's okay, Samantha, you haven't missed anything yet. Just giving it a couple of minutes for people to hop on. Everybody, yeah. Everybody and their attorney needs an attorney. The attorneys are going to be getting attorneys next. How did we end up with the same response of Jennifer Coffindaffer's viewers? I don't know. I don't know. Sometimes I do agree with Jennifer. Often I don't, but sometimes I do. And, you know, I have my own opinions. So maybe Jennifer's viewers are agreeing with me rather than me agreeing with Jennifer's viewers. I don't know. I don't know. All right. So let's start reading. I'm just going to read it through and I'll comment where I feel it's necessary. How did the mother of 4... Hold on. How did Westphal know the mother of 4 stood there? Because he lived there. He lived there at the time. He lived in Flora. That's how he knew. Okay, so introduction. Over 5 years after teens Abigail Williams and Liberty German were brutally murdered in Delphi, police announced that they had arrested Richard Rick Allen for the murders, concluding a police investigation that has captured the world's attention and involved thousands of tips. At his initial hearing and clad in protective gear for his own safety, Rick told the court he would be hiring private counsel. Rick was transported to the DOC, Department of Corrections, for safekeeping. The judge removed himself from the case. So that's Judge Diener, who recused himself. Yes, he did. He lived 8 doors down. Yeah. He was right there. He was right there, was Westphal, when the Flora fire happened. No, Star Girl. This is from the temporary counsel acting on behalf of Richard Allen for the Idaho Supreme Court case. You know, that we talked about last week about the writ of mandamus, and Judge Gull got her own attorney to deal with this. Well, this is a new thing. This is a new petition for a writ to the Supreme Court, in addition to the one we talked about last week. So these are Mark Lehman and Cara Wernicke. Yes, Indiana. Yeah. Did I say Idaho again? Sorry. I'm always saying Idaho when I mean Indiana. I don't know why. I keep doing it. I do apologize. If I say Idaho at any point during this live stream, I mean Indiana. I don't know those 2 states. I just can't deal with it. I can't deal with them both beginning with I. Oh dear. Thank you, Luna Blue, for the $5. Thank you so much. And YouTube tells me that it's your first super chat on a live stream. Okay. We've only just started reading, Bev. I'm literally on the first page. So you actually haven't missed anything. Okay. This is just the background. So Rick was transported to Westville, Department of Corrections, for safekeeping. The judge removed himself from the case and a special judge was appointed. So this was very soon after the arrest, Judge Diener from Carroll County recused himself. And then Judge Francis Gull from Allen County was appointed as the special judge to deal with this case. A week later, Rick threw himself at the mercy of the court and requested a public defender. Andrew Baldwin and Brad Rosie, attorneys with a combined 50 years of experience, were appointed. So it was Judge Gull that appointed Baldwin and Rosie. Presumably, she thought that they were all right then. Over the next year, attorneys Baldwin and Rosie zealously advocated on Rick's behalf. They appropriately asserted Rick's innocence after the public release of the probable cause affidavit. They repeatedly requested a change in the conditions of his confinement due to the obvious effects the conditions were having on his physical and mental health. And they prepared a trial strategy with Rick after pouring through thousands of pages of discovery. You spelt pouring wrong, but I'll let you off. To prepare his defense for a January 2024 trial. So I'll say yet again, jury selection was due to start on January the 8th. And I think the trial proper maybe was due to start 2 weeks after that. But yeah, January the 8th, we'd all be sitting down to watch jury selection, or at least hear about it, if Judge Gull didn't allow cameras in the court. But anyway, that's not happening now. His trial has been set for October 15th through to the 31st. So she thinks that it's only going to take 2 weeks for a trial, which in my opinion is very telling. But let's carry on reading this document. During that time, Rick never complained to the court about his attorneys. On the contrary, he unequivocally stated his desire to have attorneys Baldwin and Rosie continue their zealous representation. Yes, he sent a letter to the court, which Judge Francis Gull shat on. She used it as toilet roll. Okay. Yes, then 3 months before trial, the court removed attorneys Baldwin and Rosie as counsel, citing its extrajudicial finding that counsel had engaged in gross negligence. At Rick's direction, attorneys Baldwin and Rosie entered appearances as private counsel, agreeing to continue representing him for free, pro bono. So Richard Allen was denied his Sixth Amendment right to have counsel of his choice. These were private attorneys. So any argument about, oh, well, he was given 2 new public defenders, and as a public defender client who doesn't have money for private counsel, then he should just be thankful that he's got attorneys at all. But no, he'd appointed private counsel. The fact that they were working pro bono is completely irrelevant at that point. Okay. But this finding that she allegedly has found, we have no idea what that is, because we've heard from Brad Rosie what he believes it is, but we don't know what it is because she didn't hold a public hearing. She made this finding in her own head and didn't communicate this to the public. We've just got to accept that what she says, and more importantly, Rick Allen has got to accept that what she says goes. Do I think Richard Allen is innocent? I sound biased. At this point, it's irrelevant whether I believe Richard is guilty or innocent. This is about due process. This is about the fair trial that everybody, regardless of their guilt or innocence, is afforded in any civilized society. And I'm not American. I've never been to the United States, but I'm led to believe that the United States is a civilized society. So everybody has a right to a fair trial has a right to their rights under the US Constitution to be held, and for judges to uphold Indiana, in this case, state law. All right. Okay. So it's irrelevant whether I believe he's guilty or innocent. I believe he should have a fair trial, and that is the only way that there is ever going to be justice for Abby and Libby. Simple as that. Keep saying it, and I'll keep saying it. I'll say it until I'm blue in the face, till everybody's left my channel because they're sick of me repeating the same things over and over. Is guilt or innocence at this point completely irrelevant to this conversation, which is really sad because, you know, we're into the realms of pretty much uncharted territory, because Judge Gull has shat on the US Constitution and she shat on Indiana state law. There we go. All right. Just my opinion, obviously. But at a hearing held on October 31st, 2023, the court told Rick that it had grave concerns about his defense team, that he was entitled to a vigorous defense. I don't think there could have been any more vigorous. Whether you believe the Odinism theory has any merit or not, you cannot, absolutely cannot state that his defense wasn't doing their job to a brilliant degree. You can't argue. You can't argue that a defense that put up an alternate theory in the way it did, that created reasonable doubt. I did a poll on my channel, and 21%, which would have been like two to three jurors of a 12 person jury, would have believed that Richard Allen is innocent at that stage, right? At that point, knowing what we know. So I did the poll a couple of weeks ago. And that would have been two or three jurors who believed that Richard Allen was innocent. That's a hung jury. And that means it's a mistrial. So you cannot say that his defense weren't rigorous. Can't say that. All right. And that the court cannot allow these attorneys to represent you. I can't do it, sir. I just can't. Oh, bless. Get the world's smallest violin out, because, you know. No, Brad Rosie is not Bridge Guy. No. Okay. Rick's trial has been reset for a year from now, and he has been forced to start over with new attorneys, friends of Francis Gull, the most honourable Francis C. Gull. William Labrato is the chief public defender in Allen County. They're friends on Facebook. She's a friend of his wife on Facebook. She comments on his posts, little things about his children, about how lovely his children are. Listen, when I worked at university, right, we weren't allowed to befriend students on Facebook. We weren't allowed. I don't know what would have happened if we did, but we weren't allowed. We were expressly told at two different universities. We were told, do not befriend students on Facebook. All my students were 18 years and above. Why weren't we allowed to have students on our Facebook? Because there's a conflict of interests. It's the same deal here. All right. And the other attorney, Robert Scremin, went on the media when Richard Allen was arrested, saying that he thought he was guilty because of the bullet. So now this guy, Robert Scremin, is now representing him. How's that fair? Dear God. All right. Rick has an original action currently pending in this court under case number 23SOR302 concerning the lack of public access to the court records in his case. So we talked about all of that last week. It's that writ that Francis Gull has got the attorney for, to help her out with this situation. This is a new thing that will have plopped on dear Fran's desk this morning. All right. Leaves it massively open for appeals. And what it does do, therefore, if Richard is convicted and he appeals, which he has a right to do, then it's going to drag the justice process out for years. Do you think Abby and Libby's family want this process to be dragged on for years? No, me neither. So it's important. It's important not just to uphold the Constitution, not just to uphold the state law, not just for a fair trial for Richard Allen, but also for Abby and Libby's families. They've waited long enough. The very least they should be guaranteed is a fair trial. Come on. And if Rick's acquitted, Rick's acquitted. But if he's convicted, then he's going to appeal, and he's got massive grounds to. Okay. The lack of transparency is an important societal interest, but the issue here implicates Rick's fundamental constitutional rights to counsel and a fair trial. Okay. Exactly. If due process is not adhered to, why have a judicial system at all? Exactly. Why? Why don't we just resort to vigilantism and let's go and lynch the person that we think has wronged us? Let's go back to medieval times. Let's dispense with lawyers and judges. Let's just do it the old-fashioned way. Yeah, let's do it. All right. All right. I'm game if you are. I'll win. All right. Background. Rick requested and was appointed competent and experienced counsel. On October 28, 2022, the state charged Rick with 2 counts of murder. Officers arrested Rick and took him into custody, where he has remained ever since. The Carroll Circuit Court ordered Rick transported to the Westville Department of Corrections for safekeeping due to a toxic and harmful insistence on public information from the media about the case. Now, I'm not understanding why it was necessary to send Richard Allen to Westville. I mean, we've become aware of the reason why now. It's because he could be looked after, nurtured by 2 guards who were in ordinary trust patches and who were filming his interactions with his attorneys, walking him about on a chain leash like he's some kind of zoo animal. All right, all of that aside, it was for his own good, because apparently a county jail couldn't deal with it. A county jail, no, not good enough. Obviously, they didn't have enough ordinists working there. So Carroll County, couldn't deal with it. Cass County, so on the other hand, when they became aware of the dire circumstances Richard was in earlier this year, they actually volunteered to take him and said, we can look after him. But Judge Francis Gull denied that. She's denied that at least twice, to my knowledge now, because obviously they can't care for him as well as these ordinary guards. They care for him way better. All right, make him confess and everything, All right. The fact that he's lost at least, I don't know, £40 at this point, irrelevant. The fact that he was so mentally deranged that he was eating his paperwork, that's irrelevant also. All right. Okay. But yeah, blame the toxic and harmful insistence on public information. Okay. All right. Let's blame them. After sending Rick to the Department of Corrections, which I may add is a prison which locals, and I believe them, have told me is a hellhole. He's the only innocent person in there. And you might say, Michelle, what do you mean innocent? Well, I mean that everybody in civilized society is innocent until proven guilty in a court of law. That's what I mean. This is why it's irrelevant whether he actually is innocent or guilty at this point. It's about fair and just treatment of him awaiting trial. So there's that. Yes, it's Rick in this document. I'm reading this document. If anybody's got a problem with me calling him Rick, that's what he's called. That's what he goes by. All right. Okay. After sending Rick to the Department of Corrections, the judge recused himself. Okay, so we're still on Judge Dina now. All right, we're still on Judge Dina. Oh, so it was Judge Dina that appointed Baldwin and Rosie. All right, okay. All right. The Honourable Francis C. Gull accepted an appointment as special judge. Rick requested a public defender to represent him. Attorneys Baldwin and Brad Rosie were appointed as Rick. Oh, okay, so she did. She did appoint him. I thought she did. I thought it was her. Because Dina recused himself very early on. Very early on. All right, see you later. So you'll be back late tomorrow, will you?
Yeah.
All right. See ya. Exactly. Thank you, Scott. Francis is setting a precedent, just not the way she thinks it ain't good. It ain't good. Exactly. It's dangerous. It's dangerous. If she gets away with this, and she gets away with asking the prosecutor his opinion on which defenders he should have, that's a very dangerous precedent. And that's not a dangerous precedent for the good people of Indiana. That's not a dangerous precedent for the good people of the United States of America. That's a dangerous precedent for every person living and who will live in civilized society moving forward. It's very dangerous. It's giving power to a judge, to the government, that they do not lawfully have. And people come into my comments and say, but the judge is the law in the court. The judge, listen, yes, the judge is the judge of the law, right? The jury are the judge of the facts in a trial. However, the judge isn't there to take one side or another, to ask the prosecutor's opinion on which defenders he should have. Come on now. Come on now. The judge has got to abide by the laws of the land. The judge, it might be the law of the court, but she's the law of the court as an arbiter to ensure that due process and the law is followed on both sides. This is why the scales of justice are balanced, right? The judge holds the scales of justice, which are balanced, each side, and she's in the middle as the arbiter to ensure that the law is followed correctly and to its fullest extent. Exactly, DC Primetime. The jury is the finder of the facts, unless it's a bench trial. Exactly. When I was, I know I'm in the UK, but we have the same legal system as in the United States. All right. So when I was a jury member on a murder trial, when we were sworn in and etc., the judge said to us, I am the judge of the law in this court, but you are the judge of the facts. And absolutely. But until this case gets to trial, the judge has absolutely zero, zilch, nada, none. And even when the trial is ongoing, she cannot express an opinion about the evidence. She can't. She can't. It's not her job. Not her job. All right. Okay. Requests the public defender to represent him. Attorneys Baldwin and Rosie were appointed. Attorney Baldwin is one of the only 4 Indiana attorneys certified as a criminal trial specialist by the National Board of Trial Advocacy, as authorized under Indiana Rule of Professional Conduct 7.4. So this is Baldwin, all right? He has nearly 30 years of criminal trial experience, handling hundreds of jury trials and representing numerous defendants charged with murder. Attorney Baldwin has never been disciplined or suspended, unlike William Labrato, who has been disciplined. He has been suspended from his duties. Now, we don't know why. That's not in the public domain as far as I know, but he has. So weigh that up. Weigh that up. Attorney Rosie has over 20 years of criminal trial experience, handling thousands of cases, including 8 murder cases. Attorney Rosie practices regularly in Carroll County and surrounding counties. He was born and raised in adjoining Cass County. So it's Cass County that he has the links with. Cass County offered to house Rick Allen. They said they could keep him safe. They had the capacity, they had the ability to keep him safe. If you don't think a county jail can keep somebody in a high-profile case safe, well, how did Chris Watts stay safe in Weld County, Colorado then? How did he stay safe? How is Brian Koberger currently staying safe? In the tiny, I think they've only got it's like 12, I think it can hold 12 people, I think, Latah County in Idaho. Which case is bigger? Right? I think the Delphi case and the Idaho 4 case, I think they've had similar amounts. Yes, the Delphi's gone on longer. But seriously, if people wanted to get to Brian Koberger, some swift justice of their own, right? Do you think they'd get away with it? No, because Latah County Jail are keeping him safe. So it's a complete misnomer. It's a complete it's nonsense. It's nonsense to say a county jail can't keep a defendant in a high-profile case safe. Brian Koberger looks better now. He looks healthier now than he did before he went to jail. How's that working out? Listen, at the hearing last week, it was Zoom. I streamed it, so check it out if you've missed it. It was on Zoom, right? It's a judge on his own in the courtroom, right? And Ann Taylor, Brian Koberger's public defenders, there on Zoom. Where is she? Wasn't at home, like the prosecutor looked like he was. No, she was downstairs. She was downstairs in the courtroom. What's downstairs? The jail. She sat there in the jail with Brian Koberger on Zoom. Do you think that Ann Taylor, I'd have heard her from here, and I don't know how many thousands of miles Idaho is from where I live in northern England. I don't know, maybe 7,000 miles, 6,000 miles. I've no idea. I would have thought, you'd have seen the mushroom cloud. I would have thought there'd been a nuclear explosion or something, because she'd have flipped her lid. Right? She'd have flipped her lid, and rightly so, if guards had come along with a video camera, videoing them, having a meeting. Quite rightly, she would have flipped her lid. But that's what was happening to Richard Allen when he was meeting with his attorneys. Do you think she'd be sitting there on Zoom in the jail if she thought that there was something horrible going on? No. She'd be banging heads together and breaking him out. Rightly so. So how is it that Brian Koberger, the defendant of a quadruple murder, is kept safe and is being looked after, and who now looks healthier than he did before he went in, that he turns up at hearings in a suit, right, that nice hairdo, you know, splash of cologne, walks in a suit. Richard Allen, right, has got a shock vest on, is in chains, is shackled at the ankles. He fell down the stairs, you know, because the elevator wasn't working. Fell down the stairs on the 31st. Did you know that? And he's got like, I don't know, about 6 burly guys. He's 5 foot flaming 4. I bet he's not 130 pounds wet through by now. What do they think he's going to do? All that is for show. That's for show. There's no reason why Richard Allen can't turn up at a hearing in a suit and walk into the courtroom like Brian Koberger does. There's no reason. There's no difference between the cases. Brian Koberger, in a death penalty state, is accused of a quadruple murder. Richard Allen, in a death penalty state, is accused of a double murder. There's no difference between them. No difference between them. Anyway. Okay. Where was I? All right. So, Rosie was born and raised in Cass County. He's intimately familiar with the police officers and prosecutors investigating and prosecuting this case. Attorney Rosie has never been disciplined or suspended, unlike William Labrato, who has. Rick wants this partnership to handle his defense. Okay. Rick's lawyers issued a press release affirming Rick's innocence. Now, this was in November. So this was a month after Rick was arrested, and there was no gag order at this time. No gag order at this time. You wonder how the Odinists feel about Odin's portrayal in Avengers. I don't know. That's a good one. Okay. So this was pre-gag order, right? On November 29th, 2022, the charging information and probable cause affidavit in Rick's case were made available to the public. Just after the election of the new sheriff, I might add. Attorneys Baldwin and Rosie issued a press release. They did. And it was a very nice press release. It was, there was not inappropriate. Yes, they expressed that they believed that their client was innocent. They expressed their belief that the probable cause affidavit was very thin. All right. I played a 6-minute Andrew Baldwin talking to reporters outside of the courts in a video last week. And it was nothing to see here, just what a defense attorney says. I believe my client is innocent, will prove his innocence, blah, 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 blah. At the time, I took it as a grain of salt, right? That's what defense attorneys always say, isn't it? Okay. All right. So they issued this press release, which responded to the allegations contained in the affidavit, reasserting Rick's innocence, and indicated they would continue to share exculpatory information with the public to the extent that they were ethically permitted to do so. All right. Exactly, CHORLEY. Brian Koberger's not coming from a state prison, exactly. He's in a county jail that's quite capable of keeping him safe and healthy. So if it's good enough for the goose, it's good enough for the gander. All right. Okay. Later that day, the court entered a gag order prohibiting the parties from making extrajudicial statements about the case, which was reaffirmed after a hearing. So it was that day, it was the day that the defence spoke to the media that they issued a gag order. Bearing in mind the defence didn't say anything to the media that was jeopardising the case, dealing with, perverting the jury pool, nothing. Just they believe the client's innocent, they're going to prove the client's innocent, and the probable cause affidavit's thin, and it was pretty much that, right? But no. Even though, right, there'd been a press conference when he was arrested. So how is the defence issuing a press release when they received the probable cause affidavit any different than having a press conference when an arrest's made? How is that different? How is that different? It's not different. All right. The court also entered a protective order prohibiting the parties from divulging or granting access to the discovery material to all but certain people, which is surely standard. Right? You don't give the discovery away before a trial, surely. On December 21st, 2022, Rick's counsel, Andrew Baldwin, inadvertently emailed a summary log of the evidence on a flash drive received during discovery. I remember that. He was supposedly emailing it to Brad Rosie, and he emailed it to somebody whose first name began with B-R-A. Come on, who's not done that? Who's not done that? When you're an old person, right? And even when you're not an old person, I did this when I was quite a young person. You email the wrong person because the address bar for your email, it adds things in. Right? What's it called? Predictive text, right? So he was guilty of predictive text, and he emailed this summary log to an entirely different person than he intended. All right. The log did not contain any substantive evidence, but was similar to a table of contents. All right. Okay. Due to his declining mental and physical health, Rick asked to be moved out of the maximum security segregation confinement. On April the 5th, 2023, Rick moved to modify the safekeeping order, arguing that he was unrepresented when the order was entered and that no hearing had ever been held on the motion, and that he was being held in a maximum security segregation unit at Westville Correctional Facility that is generally reserved for violent convicted offenders, and that Westville has a history of unequal and inhumane treatment of its inmates. Okay. As I said, locals have said to me that this place is a hellhole, and I believe them. All right. Now, I think all prisoners should be held humanely, whether they're convicted or whether they're awaiting trial. There should be humane treatment. No, that doesn't mean, all mod cons. It doesn't mean every single whim and want catered for. No, I'm not saying that in any way, shape or form. I'm not saying that. But things like, basic rights should be, rights to not being tased when you've not done anything wrong. Things like not having meetings with your attorneys filmed, those kind of things. But also not to live in constant fear, not to have other prisoners perched outside of your cell door, supposedly looking after you, as is allegedly happening to Richard Allen. Okay. Rick described the conditions in which he was being held, as well as the obvious decline in his physical and mental health. Now, I'm going to say that this motion from April, I read it through again the other day, and it's strongly worded. I've got to tell you, it's strongly worded, but there's nothing in it that I don't believe isn't true. Okay, but it was strongly worded. Rick explained the significant hardship his placement in Westville had on his ability to assist his attorneys in preparing his defence. The court denied the motion, reaffirmed its prior order, and clarified that the Department of Corrections could move Rick to accommodation of its needs. Clarified that the court denied the motion, reaffirmed its prior order, and clarified that the Department of Corrections could move Rick to accommodate his needs. Attorney Rosie filed a tort claim notice to preserve Rick's rights to obtain private counsel in the future to file a civil suit relating to the conditions of his confinement. Rick and his attorneys formulated a strategy of seeking a speedy trial and pursuing a defence of third-party guilt. Oh, are the trolls going on? Is there a troll? Who's trolling? Who's trolling? Just don't feed the trolls. I can't find where the trolls are, but just don't feed them, just ignore them. Or if you're a mod, just put them in timeout if you see anything trollish. I mean, different opinions is fine. Different opinions is fine. I'm happy with that, right? As long as it's all respectful. You can argue back and forth as long as it's respectful. But don't anything obviously trollish, then put them in timeout. And you guys who aren't mods, just ignore them. They'll go away. All right. Okay. Rick and his attorneys formulated a strategy of seeking a speedy trial and pursuing a defence of third-party guilt. Rick's counsel continued to file motions to change his confinement conditions. He and his attorneys also developed a trial strategy of seeking a speedy trial and pursuing a defence of third-party guilt. Several months before trial, Rick filed motions to suppress evidence, a motion in limine regarding the ballistics evidence and a request for a hearing under Franks v. Delaware. Okay, so requested a Franks hearing. So we all know about the Franks hearing by now, right? Rick also signed a motion for speedy trial, which Rick's attorneys plan to file in early November to lock in the January trial date. During a telephone conference with the court in early October 2023, Rick's attorneys informed the court that they were ready to proceed to trial in January. Okay. Did you know under the US Constitution that everybody has a right to a speedy trial unless they expressly waive that right, as Koberger has? Right, everybody has a right to a speedy trial. Do you know what the US Constitution denotes as a speedy trial? Do you know it? You're American? Don't look it up. Do you know it? If you're not American, do you know it? I didn't know it until the other day when I looked it up. What's a speedy trial under the US Constitution? Six months there, Star Girl. No idea. Well, it's it got a lot of variation. It got a lot of variation. A lot of people saying 6 months. Now, what I read, and I might be wrong, is a year. That doesn't include, like, let's say, for example, that your defense puts in a request for a continuance. That doesn't count. So it's 100 days. Depends on the jurisdiction. Talking about the Constitution, what does the Constitution say? I'm going to have to look it up because I found it the other day. Okay. Right to speedy trial, US. Don't give me a lot to read here in the middle of a live stream. Oh, you're giving me too much to read. All right, well, there is. Sixth Amendment guarantees the rights of criminal defendants, including the rights to a public trial without unnecessary delay, the rights to a lawyer, the right to an impartial jury, blah, blah, blah. Are you going to give me a link? Speedy trial. The right to a speedy trial is enshrined in the Sixth Amendment, the United States Constitution, blah, blah, blah. Well, I read that it was 12 months. But I've got so much variation in the chat. I think it's to the start of a trial. But anyway. The right to a public trial without unnecessary delay. Give me a time span. Anyway, okay. So, he wants a speedy trial, okay? Wants a speedy trial. Not waived his right to a speedy trial. So, doesn't want any delays. The trial court removed Rick's chosen counsel over his objection. Okay. In August 2023, a former employee of Attorney Baldwin, Mitchell Westerman, stopped by Baldwin's office to visit. Westerman slipped into a conference room where he found crime scene photos and, by his own admission, secretly photographed some of the discovery material and disseminated it. So, Speedy Trial Act 74. Is that what it's called? Speedy Trial Act. Speedy Trial Act 1974. Finding the Sixth Amendment right to a speedy trial. Huh? Speedy Trial Act 1974, defining the Sixth Amendment. The Speedy Trial Act mandates that by 1980, the period of delay in all federal and district courts shall not exceed 100 days, subject to. Yeah, that's a delay, though. Why are you all in caps? Why are you shouting? Only I'm allowed to shout. I don't know that 100 days is right. 100 days is not very long. It's like, okay, 100 days is long. An indictment within 3 days. I knew that. A trial must begin within 70 days unless a speedy trial is waived. It also depends on the type of case. Misdemeanor gets 12 months in Tennessee. Indictment within 30 days, not 3. Well, if it takes 30 days to indict you, and then your trial's in 100 days. Speedy trial in Indiana is 70 days. Wow. I honestly can't see that benefits either side, though, honestly. Because how are you able to fully go through the discovery and get all your ducks in a row in 70 days? 70 days after facing officer of the court. Okay, 70 plus 30 is 100. Well, I can't remember where I read 12 months. Because 12 months, you see, in this country, it's unusual to wait a year for something to get to trial, but it does happen. Hello from Southern California. Hello, hello. 70 days in Indiana counting from day one of the filing. Every state is different. Before they charge you, they're supposed to have their ducks in a row. Well, they are. They totally are. Remember, local control exists in the US. Yeah, but speedy trial is 120 days from beginning to end. All right, I'm gonna believe you. I'm gonna believe you. I'm gonna believe that what I read, whatever it was that I read the other day, was wrong. Sonia, member for 18 months. Hello, hello. All right, let's get back to this. Okay, so Mitch Westerman. I do have a problem with Mitch Westerman. I want to see the affidavit that he filed, which is strangely been sealed. Another thing that's sealed without anybody seeing it. And I want to know his motives. I want to know who put him up to it. And also, I want to know, as I said the other day in a video, I want to know why it's perfectly fine for Jerry Holman, one of the detectives on the case, to be giving out information about the crime scene to podcasters without any redress or discipline. I want to know why he's not been fired. If anybody can tell me that, why it's okay for Jerry Holman to give away information about the crime scene, but it's not okay for anybody else. Let me ask that. Okay. All right. Attorney Baldwin was not aware Westerman had done this. When counsel learnt the material had been disseminated, they disclosed the matter in an email to the court and the state on October the 6th. The prosecutor responded that he had known about the leak for a day and that the state was investigating the matter. But the state didn't bother to contact the defence to say, "Oh, you've got a problem. You got a problem in your office." Didn't bother that. No, didn't bother. No. Was going to do all of this before the defence even realised. Cats and Crimes. Welcome to memberships. Thanks for joining the Secret Agents Club. Thank you. Thank you. On October 9th, Westerman told Attorney Baldwin about his inappropriate, if not criminal conduct, in secretly photographing and the discovery items. Rick's counsel informed the state and the court the following day. The parties had a telephone conference with the court that day to discuss the matter, and the state mentioned the issue of disqualifying counsel. A day later, counsel informed Rick of the matter, and Rick immediately and unequivocally indicated he still wanted his attorneys to represent him, believing their representation was in his best interest. This letter was filed with the court on October 12th. As an attachment to a letter filed by attorney Rosie. After receiving Rick's letter, the court notified the parties that it was scheduling a hearing on October 19th to address other matters which have recently arisen, and ordered Rick's counsel to cease work on Mr. Allen's case. All right. On Rick's request, the court ordered the attorneys to appear in chambers at 12:30 before the hearing to discuss what was expected at the hearing. Attorney Baldwin filed a memorandum regarding the possible disqualification or sanctions, explaining the circumstances regarding the theft of discovery, the law regarding a criminal defendant's constitutional right to counsel, the court's limited authority to remove appointed counsel, and a proposed sanction in the event it was warranted. Okay, so we read that. That was filed by David Hennessy, who was attorney Baldwin's lawyer. On October 19th, the judge opened the courtroom to the media and, for the first time, authorised 1 or 2 cameras providing pool coverage to be permitted in the court session. The attorneys appeared in chambers without Rick being present. During the conference, the trial court read a prepared statement to Rick's counsel, accusing them of gross negligence and citing specific examples of their zealous advocacy as purported acts of their negligence. These purported acts of gross negligence include the following. Okay. Issuing a press release before entry of the gag order, filing motions to protect Rick's health and safety, which the court believed lacked evidentiary support. You only needed to look at him. Unintentionally, and they've since admitted stuff, right? Unintentionally emailing the discovery log to a third party. Okay. Silly, but I doubt that constitutes gross negligence. Unspecified improper statements made in the motion to suppress. No idea what that's about. Filing a tort claim notice to preserve Rick's rights and seek redress for the conditions of his ongoing confinement. Attorney Baldwin hiring a lawyer to appear on his behalf on the issue of sanctions or disqualification. So him hiring a lawyer is his own business. Him hiring a lawyer, he has a perfect right to do so. How's that gross negligence of Richard Allen's defense? Come on now. A third party impermissibly photographing discovery without the knowledge or consent of either lawyer. The court then informed Rick's attorneys that they had 2 options. 1, voluntarily withdraw their appearances, or 2, be disqualified as counsel after the court read its prepared statement in open court. Attorneys Baldwin and Rosie met with Rick to discuss the matter. Rick disagreed that his trial counsel had engaged in any negligence, and he reaffirmed his desire for them to remain as his counsel. Rick's attorneys informed the court that they had believed the court had engaged in an unconstitutional ambush of Rick and his counsel without due process. Okay. Counsel also informed the court that they believed their withdrawal was involuntary and done under duress, since their refusal to withdraw would have publicly disparaged their representation of the accused, framing their advocacy on his behalf as gross negligence, and cast Rick, his attorneys, and the merits of his defense in a negative light. That's what, obviously, Judge Gull wanted, in my humble opinion, and was pretty pissed off that she didn't get the opportunity to do that. Toby's very shady. Toby is a very shady character. Jerry Holman is also a very shady character. Okay. And Liggett, well, in my opinion, allegedly. Such a public statement risks tainting the jury pool, harming their client's defence, undermining their professional relationship with their client, and possibly creating an actual conflict for their continued representation. Faced with this dilemma, Attorney Baldwin orally moved to withdraw his appearance, and Attorney Rosie informed the trial court he would file a formal motion to withdraw his appearance at a later date. Attorney Rosie did not withdraw. What's this footnote here? The court reporter declined to provide a transcript. What? What? The court reporter declined to provide a transcript of the in-chambers proceeding, and the court did not rule on Realtor's motion for the transcript. Realtor is relying on the recollection of Rick's attorneys memorialized shortly after the proceeding. Seriously? What? So Brad Rosie requested the transcript of the meeting, like the in-chambers meeting, requested a transcript. That's been denied. The court reporter. What? The court reporter say, no, you can't have a transcript of a meeting that you were at. How is that even lawful? Unbelievable. Unbelievable. That's insane. That is insane. I don't know why they've put that in a footnote, because people don't read footnotes. That should be in bold, like in double font. That's unbelievable. Why? What's the problem with giving all members of everybody who was at that meeting access to the transcript? Surely that would be something that would be available. The court reporter wouldn't have any more work to do. It's not like they're specially prepared. The court reporter's there. The court reporter's doing the reporting, taking things down. The transcript's available. Why can that not be just made available to everybody who was at that meeting? They don't want leaks. They don't want leaks at a meeting that should have been at a public hearing anyway. Okay, then. All right. That makes sense. Okay. The judge entered the courtroom, went on the record without Rick or his attorneys being present, and stated that there was an unexpected turn of events. It was unexpected. I doubt there's a transcript. There is a transcript. The court reporter was there. The court reporter was there doing what court reporters do, taking down that machine thing that they use. There is a transcript. If there's no transcript, well, is there an audio recording? The transcript could be sealed. It could be, yeah. There's no reason. The members of that meeting should have a copy of that transcript. Without a doubt. No question. Not without a doubt. Okay, all right. So Judge Gull came in, as we all know, said there's been an unexpected turn of events. She looked really pissed off. We thought it was because the attorneys had withdrawn and that created a massive problem. But no, the unexpected turn of events was that she'd invited the cameras in my opinion, of course, because she wanted a public showdown and she didn't get one. All right. Okay. Rick's lawyers had withdrawn from the case. The court concluded the hearing by noting that the state had some witnesses here that came earlier to have the hearing, but clearly this is outside of our control. In a written order, the court noted that Rick's pre-trial motions were still pending due to the court be still reviewing the exhibits submitted by counsel. So this is the need for a Franks hearing. Okay. To continue pursuing Rick's trial strategy, counsel remained in the case as private counsel, but the court disqualified them. Attorney Rosie filed a notice indicating that Rick did not want him to withdraw as counsel. This notice informed the court that there was no circumstances under Rule 1.16 of the Indiana Rules of Professional Conduct which warrant the withdrawal of counsel, and that everything cited by the court as alleged gross negligence was the product of ethical lawyering in the best interests of the client's defense and mental and physical well-being. The notice also indicated that Rick was asserting his constitutional rights to counsel of his choice and wanted counsel to move forward with the representation of defendant Allen until a final disposition of this matter. Finally, the notice indicated that Rick was prepared to go to trial on January 8th, and any continuance of the trial beyond that date would prejudice him. So they were ready to go. Gung-ho, ready to go. Okay. Smash that like button. Yeah. Get to 1,000 likes. I'll give away 20 memberships. I don't think we'll get to 1,000 likes because there's not even close to 1,000 people in chat, but you never know. Bring your friends, and you might win a membership. Share the stream to everybody. And 1,000 likes, I'll give away 20 memberships. All right. Rick, by counsel, also filed a motion seeking the special judge's recusal. The trial court ordered the clerk to remove Rick's filings from the record because Attorney Rosie was no longer a counsel of record. The court also appointed 2 public defenders to represent Rick. Okay. Attorney Baldwin filed a motion requesting the court reconsider her order to remove he and Rosie as Rick's counsel of record. In the motion, Attorney Baldwin argued that his oral motion to withdraw was involuntary. The court ruled outlining the proper procedure to withdraw as counsel were not complied with. He and Attorney Rosie were not disqualified and remained as counsel of record at the time they filed a motion on Rick's behalf for the judge's recusal. The court lost jurisdiction to take any further action in this case until the motion to recuse was resolved, and removal of counsel interfered with their attorney-client relationship and prejudiced Rick's constitutional rights to counsel. I agree. If surely, right, this is just based on logic, no legal knowledge of this at all, but based on logic, right? If an attorney files for a judge that they've got so deeply concerned about a judge that they file a motion that the judge recuse themselves, so that the judge withdraw from the case, surely that can't be that judge who then just denies that ever existed, who just tells the court clerk to remove it from the system, that it just doesn't exist. Surely that's not how it works. Surely they have to get another person in to judge that particular issue. Surely. You can't... Look, right, listen. If let's say, for example, I complained about my boss. Let's just say this. I put a formal complaint in about my boss because of whatever I thought they'd done wrong. My boss can't just turn around and say, oh, well, I'm just going to throw that in the bin. Surely, if it's a formal complaint, surely they have to get another person to come and adjudicate that, to come and deal with that. Either the boss's boss or somebody who's of equivalent standing of that boss. Surely that's how it works. Surely you can't just say, oh, well, that didn't happen. Ah. The day before a hearing scheduled on October 31st, attorneys Baldwin and Rosie entered their appearances as Alan's retained counsel. In their appearances, Baldwin and Rosie asserted their belief that they were improperly removed as counsel of record and that they were now entering their appearances as private counsel in order to protect Alan's constitutional rights to a fair and speedy trial and in honour of his 4th, 5th and 6th Amendment rights. Okay. On October 31st, a hearing was held. Attorney Baldwin stated that Rick had asked them to represent him, so they were re-entering their appearances. The court asked what had changed in the 12 days since they had chosen to withdraw rather than be removed. Attorney Rosie argued that their withdrawal as counsel was involuntary so as to avoid prejudicing Alan's defence by allowing the court to disqualify them. He also argued that Rick had a constitutional right to counsel of his choice. He had asserted that right, and the court had no authority to remove his counsel without due process. Exactly, due process. If Judge Gull genuinely believes that she has got the evidence by which attorneys Rosie and Baldwin have committed gross negligence, she should hold a hearing to provide all of that evidence to the public and to Richard Allen as per the law that she has to abide by. I don't understand how she can do this in private and get away with it. And just say, oh, I've made a finding. That's what she said. I've made a finding. Well, have you? Well, do you want to share the evidence with all of us of your finding? Let's hear it. She does not have to provide any evidence to the public at all. Okay. All right. She has to provide evidence of her finding that the judges, that the attorneys were grossly negligent. The leaks don't change anything. The leak does not change the right that Richard Allen has to his attorneys. It doesn't change the right that the attorneys have to a due process of a hearing, an actual hearing that disqualifies them. A leak does not change that right. Also, while we're on it, I'll just repeat that if you think that the leaks change everything, right? How do you feel about Detective Jerry Holman giving details about the crime scene to a podcaster who then went on Court TV and told the world. How do you feel about that? Because nothing was said about that. How do you feel about detectives spoon-feeding podcasters with the crime scene information? If you believe that the leaking of crime scene information from Andrew Baldwin's office without his knowledge or consent, okay, has tainted the jury pool, has done this, that, the other, well, Jerry Holman, in fact, several investigators, in that podcaster's own words on Court TV. Do you need me to play it? You need me to play it? You need me to play it? All right, we'll play it. All right, you've asked me nicely. We'll play it. All right, okay. Because it's in my video from the other day. Okay, so it's not difficult to find. Here we go. What's good for the goose is good for the gander. Okay. All right.
It's time for you guys to start being journalists.
All right, just a minute. Just let me find the bit. Okay, we'll play this. Play this here. Come on, where is it? Here we go. All right. Okay. All right, you listening? Okay. Okay. Listening. Let me know that this sounds okay. Let me know you can hear it and everything. Just going to play this. It's from my video from 2 days ago. If you want to go and see it, it's called "What's Good for the Goose is Good for the Gander: The Delphi Leaks That Were Not Punished." And I'm playing a clip here from Court TV. Thank you, Nellie B, for joining the memberships. Welcome to the Secret Agents Club. Here we go. Let me know that the sound is okay. What Barbara McDonald actually said. Here it is.
So let's talk some more about this. Joining us right now in studio, co-host and producer of Down the Hill, the Delphi Murders podcast, and Court TV senior writer Barbara McDonald is with us. Barbara, let's start here, okay? You've seen different depictions of those stick formations that everyone's talking about now, these stick formations on the two girls. What have you seen? And let's begin with Abby.
All right, so I've been hearing about these stick formations and this image on the tree for a very long time, and very different characterizations than what's in this memorandum. Sources close to the investigation have provided me with drawings of what they say those images look like, the arrangement of those sticks. So let's start with the one of Abby, and it shows 3 sticks. Now, we have not placed her body here because this is how it was provided to me. We don't know exactly what the positioning on top of her was like, but this is supposed to be a representation of what the image looked like, the way the sticks were formed. Now let's put up the image from Libby, and there's 5 sticks involved here by my count, and you can look at these and decide if they look like something to you or look like they're randomly placed. I have spoken to many investigators who were on the scene at the time who say the assumption was they were randomly placed. They did not see a pattern. They didn't see intentionality there. The other thing we have an image of is what was depicted on the tree. And it's described in this memorandum as being the letter F, a rune painted in blood.
Blood, right?
That was tested. According to the memo, it's Libby's blood.
Okay.
According to the memo.
That's what the defense is saying.
Yes. I have not heard that part of it from my sources, but I was given a rendering of what the blood on the tree or whatever the substance on the tree appeared to be. And
that's what we're looking at right now.
This is more accurate. Several of the investigators told me they thought that it was a perhaps partial handprint of the person who committed the crime, leaned up against the tree, and that's how it was placed there.
So although she doesn't name names, she said that several investigators. Yeah, so several investigators. Several. Now, I heard that it was Jerry Holman, who is a detective on the case, who was one of Barbara McDonald's sources. Barbara McDonald is a podcaster. She runs the Down the Hill podcast, but she also is a correspondent for Court TV. So how come these investigators aren't being investigated? Indeed, how is it that it was Jerry Holman himself, who was investigating this leak? that it was Jerry Holman that the Murder Sheet podcast went to when, they were so concerned about this leak that had come from Andrew Baldwin's office. Now, don't get me wrong. I'm not saying that leak was right. I'm not saying that any leak is right. I'm not saying that Mitch Westerman should get away with this. I'm not saying that Mitch Westerman, it's theft. I think Mitch Westerman should be prosecuted for what he's done. I want to know his motivation, but I want him prosecuted for what he's done. If I was Andrew Baldwin, I would be pressing charges. However, how is it okay for the investigators on the case, the gag order, which includes the investigators on the case, all right, how come it's okay for several investigators that Barbara MacDonald, you heard her on Court TV, how come that's okay? She was given sketches. She was given sketches of the sticks that were on Abby and Libby, which she then gave to Court TV. How is that? How is that any different than the leaks that have come out from Andrew Baldwin's office? How is that any less tainting of a jury pool or any less problematic for a fair trial for Richard Allen? How do we know? Which is the point I just going on to in this video right here. Go and listen to it. That I said, well, all right, this is what Barbara MacDonald's admitted to, that she's been given sketches from the crime scene of the sticks, which would have been taken at the time, right? And of the formation on the tree, okay? How do we know that's all she's been given? How do we know, for example, let's just throw an example in. How do we know that Jerry Holman or another investigator hasn't been the one that's been feeding the Murder Sheet podcast with things like search warrants, with things like information about Keegan Kline? How do we know that it's just Barbara MacDonald that's been fed information and it's just the crime scene information, like the sticks and the F on the tree? Isn't she under a gag order? No, Barbara MacDonald isn't. No, Barbara MacDonald isn't. Barbara MacDonald's a reporter. She's not under. It's anybody connected to the case, or attorneys, investigators, families, I think it covers. I think. But it's not reporters, or else none of us would be allowed to... I don't know. I don't know why. I think Andrew Baldwin and Brad Rosie should be seriously looking into the detectives, because they've been against the gag order, been feeding podcasters with information. This is the point I'm making, that it should be looked into, not just by the judge, not just by us, but by Andrew Baldwin and Brad Rosie. I need them to know this. This was on Court TV last month. Which month was it? Hold on, I've got the link in my description box. It was
You worry when your teenage.
So this was Court TV on September the 20th. So that's the 2 days after the memorandum came out. So how come those cops have not been fired? Don't know the answer to that. Anyway, let's get on with this. Okay, I did say I was going to try and keep this under an hour and a half. We're now at an hour and a half, so it's going to go longer. But anyway, Anyway, it was just sketches, not graphic photography. Does it matter? Are you saying that some leaks are okay, but not others? When there's a gag order, surely any leak should be punished. Surely, any leak. Who's deciding? Well, is it okay for that to be released, or but not that? No. A leak relating to the crime scene is a leak relating to the crime scene. Okay, let's carry on. Right. The state indicated it agreed with the court that Rick's counsel was grossly negligent. The state, Slick Nick McClellan should have had no opinion on this. Slick Nick McClellan should not have been asked what he thinks about this. It's not for him to decide whether the attorneys have been grossly negligent or not. You know, that's like saying, oh, well, I'm going to let the prosecutor decide who the attorneys for the defense are going to be. Come on now. The state reiterated the examples of negligence the court had noted during the in-chambers hearing. So, yeah, they're in it together. The court acknowledged that Rick had chosen attorneys Baldwin and Rosie as counsel, but refused to recognise them as his counsel, stating, I have grave concerns, Mr. Allen, about their representation of you, the previous findings by this court of their gross negligence. Mr. Allen, you are entitled to an adequate representation in your case. You are entitled to a vigorous defence in your case. Nobody can say that their defence was nothing short of astonishingly good defence. Maybe that was the point. Maybe that's the problem. And this is difficult, Mr. Allen, because I know what you want. You've indicated that through your attorneys, but I cannot and will not allow these attorneys to represent you with the concerns I've had, with the gross negligence I have found. That you have found, not provided the evidence as to what constitutes gross negligence above and beyond your opinion. They withdrew rather than be found grossly negligent and be removed. I can't do it, sir. I just can't. I can't allow that. Oh, bless. Thereafter, the new attorneys requested a continuance of the January 2024 trial. The court granted the request and set an October 2024 trial date, noting that counsel had not yet received the discovery and were unable to estimate when they would be ready for trial. The new attorneys admitted they could not tell the court with any certainty that they would be ready for October. The court also noted it had not completed review of the exhibits related to the Franks motion, and that once new counsel had time to review discovery and the pleadings, they could either adopt those pleadings or make their own. Exactly. What is the gross negligence? What exactly is harm to Richard Allen's defence? Exactly. Okay. This is the grounds for the writ of mandamus. The trial court lacked any authority to remove Rick's entire defence team over his objection and based on a summary finding of gross negligence. Flower of Scotland gifted 5 memberships. Thank you so much, Flower of Scotland. You are so kind. Okay, we're all mad here. Blissful, hold on, it's jumped. Blissful Nessence. Who else have we got? Jay, Amy, and Laura. Welcome to memberships. You get a month's membership free, courtesy of Daughter of Scotland. After the month, your membership just ends. It's not a trick. YouTube doesn't take your own money or anything like that unless you choose to renew. There is a members tab. If you go to the channel homepage, you'll find the members tab, and there's members videos, there's some status updates, the stuff. So welcome for the next month. Okay. All right. Original actions provide extraordinary remedies, and accordingly, Writs of mandamus and prohibition will be issued only when there is only where the trial court has an absolute duty to act or refrain from acting. So that's state versus blah, blah, whatever. Okay. This court routinely relies on its original jurisdiction to address claims that attorneys have inappropriately been disqualified or that they should have been disqualified. So again, there's the reference. Here, trial court has an absolute duty to reinstate attorneys Rosie and Baldwin, and the remedy on appeal is non-existent. The Sixth Amendment to the U.S. Constitution provides, in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. The right to counsel embraces not only the assistance of counsel, but also the reasonable opportunity to secure counsel of one's own choice. Again, there's the reference. Okay, all right. There it is. There it is. Okay. He wants Rosie and Baldwin. They want him. They're prepared. They're prepared to represent him. They're that confident of Richard Allen's innocence. They're so invested in his case that they are choosing to act as his counsel pro bono. These are attorneys with a combined 50 years of defense experience in Indiana. Could he be in safer hands? No. And I think that's probably the problem for Slick Nick McClelland and these crooked investigators who've been caught in a bunch of lies. Bunch of lies. Bunch of lies. They didn't think they'd get caught out. They didn't think that, you know, this man who works at CVS would, you know, have the luck and the fortuitousness to be granted to public defenders who would actually do their job above and beyond what would be required for a public defender. I can't. Do you know what I would do if I was Richard Allen? Do you know what I would do? Because I'm a complete shitbag. Do you know what I would do? I would write to the judge and I'd say, I'm going to represent myself, which I have a perfect right to do. I have a right to do that in my country, just as members of the great nation of the United States have a right to do as well. And say, I'm going to represent myself. And then you know what I'd do? I'd employ Rosie and Baldwin as my advisors. What would she do to that? What would she do to that? Don't know. That's what I'd do because I'm a shitbag. Okay. All right. The attorney-client relationship is afforded the same venerable protections whether the lawyer is a public defender acting pro bono or privately retained. Indiana recognizes only two narrowly circumscribed situations where a trial court may sever the attorney-client relationship against the client's wishes. 1, the lawyer is not a member of the state bar, so no, they're both members of the state bar. Or 2, the lawyer has an actual conflict of interest that will obstruct his ability to provide effective representation. So no, that's not the case either. No Indiana court has ever tolerated a trial judge removing a lawyer from a case over the client's objection. Oh, Daughter of Scotland has gifted another 5 memberships. Wow, thank you so much. Okay, so who's got them? 0723 Trinity, Mason, Wisdom Sleuth, Glitter Witch. I thought you were a member already, but anyway. And Jill, welcome, welcome. Welcome. Okay. Removing a lawyer from a case over the client's objection based on the judge's subjective belief the lawyer is negligent or even grossly negligent. Exactly. Thank you. My point. It's her opinion. There's no actual evidence of gross negligence above and beyond her opinion. She's not entitled to an opinion. She's an arbiter. In the court, she's the arbiter. She is the judge of the law of that court, ensuring that the prosecution and defense behave themselves. Oh, you're a broke member. Okay, Glitter Witch. Well, you've got a month courtesy of Daughter of Scotland now. Okay, so, yeah. I know, Nelly. The fact she asked the prosecution for their thoughts says it all. Yeah. Not entitled to an opinion. You're entitled to arbitrate the law. And you yourself has got to follow the law, even if it's your court. It's not a dictatorship. And the courts across the country regularly issue extraordinary writs in criminal cases to reinstate defence attorneys who have been kicked off cases for conduct the trial court found upsetting or negligent. Oh, God, this has happened before. Jeez. So, is that Tennessee? Los Angeles? Don't know what that is. Or Texas? All right. So it's been tried before. Okay. Who are these detectives or judges covering for? Yeah, exactly. Who are they covering for? No, I think they've just been caught in a bunch of lies. I think they've realised they've been caught in a bunch of lies, and this is the shit's hit the fan. And they've thought, oh no, we can't let this go. And this judge is just, I don't know. She's biased. The scales of justice are not balanced. So she needs to go. When a court believes it possesses objective evidence to support a lawyer's removal, it should clearly articulate that evidence on the record and exhaust other possible remedies before resorting to the removal of counsel, such as censure, disciplinary referral, or contempt proceedings. Okay, those are her options if she has objective evidence, not just her opinion. Opinion doesn't count. Removal, if ever considered by a judge, should be an absolute last resort, and the removal proceedings should occur at a hearing where the defendant and his chosen counsel are provided notice of an opportunity to be heard on why the attorney-client relationship should be severed. Not a bunch of emails between Slick Nick, the judge, and the attorneys, who Slick Nick and the judge had already been talking about for at least a day beforehand. That's not notice, right? People who've come into my comment section saying, oh, but they knew about it before the 19th. Yes, they did. A bunch of emails, right? And a telephone call. That's not notice. It's due process. Come on. Here, the judge acted to terminate the attorney-client relationship when she had an absolute duty to refrain from doing so. This court should mandate attorneys Rosie and Baldwin be immediately reinstated. Attorneys Baldwin and Rosie were active members of and in good standing with the Indiana Bar, and there is no conflict of interest, even alleged, between Rick and his attorneys. The inquiry should end here. But attorneys Baldwin and Rosie were removed because the trial court disagreed with their conduct. The judge made a sua sponte summary finding in chambers of gross negligence after the state raised the issue of disqualifying them. Slick Nick wanted them disqualified, right? This is it. Slick Nick wanted them disqualified. So she did. That's it. She did what Slick Nick wanted. Because Slick Nick wasn't going to win, was he? Slick Nick couldn't go to trial and have his ass wiped all over the courtroom floor. Because that's what would have happened when Brad Rosie and Andrew Baldwin got into court on the trial day. Slick Nick would have shit his pants and they'd have rubbed it all over the floor for him. Sorry to be graphic. Obviously, this is not literal, right? But that's what it would have felt like. And he couldn't have done that. The world is watching. The world is watching. Yes. The world is watching and the world is not happy with this. Right? The world is, or at least the world should not be happy with this. If you are living in a civilized society and you believe you have rights, which you do, you should not be happy with this. It doesn't matter if you think Richard Allen's guilty. It's irrelevant. It's irrelevant. This should not be happening. Richard Allen, if he's guilty, if he's really guilty, he should have a fair trial and be convicted by a jury of his peers. End of. And then he should spend the rest of his life in prison or on death row. I don't know what they're going to decide. They haven't made a decision about whether they're even going for the death penalty yet. So, whichever it is, if Richard Allen, if you believe Richard Allen's guilty, then you should be campaigning that Richard Allen gets a fair trial as quickly as possible to put the families of Abby and Libby with at least closure that this is done and dusted, and the guy that did it, it's been proven beyond a reasonable doubt by a jury of Richard Allen's peers, fair and square, he's convicted, he's banged up for the rest of his life or awaiting execution. That's what you should be wanting, and this is not the way to do it. So if you believe Richard Allen's guilty, you should be campaigning, you should be furious about this, that the families have got to wait another year for it even to get to trial at the very earliest. You should be furious if you believe that Richard Allen's guilty. Not trying to find reasons why the judge has done a good thing. No. Okay. It's entirely unclear from the record what the court found was gross negligence. It could be you, Broken Goth Doll. It could be you. It could be me. It could be any one of us. It could be your son, your daughter, your father, your mother, your wife, your husband, your cousin, the lady down the road who bakes cakes for you. It could be anybody. And it cannot be allowed to continue. This cannot be allowed to happen. It cannot be allowed to happen because it could be you next. Protect your rights. R&M Productions, thank you so much. I'm a new convert to your channel. I've been watching your videos and I've been watching your live streams on the Unraveling. So thank you so much. Thank you. Okay. All right. Okay. The record only includes Attorney Rosie's recollection of the acts mentioned by the courts because Rick has been unable to obtain a transcript of the in-chambers proceedings. That's crazy to me. That's crazy to me. Nevertheless, the judge's subjective allegations of gross negligence fall into two categories. One, a mere disagreement with zealous defense tactics. Yeah, she doesn't like it. You know why she doesn't like it? Because Slick Nick doesn't like it. I wonder whether they're friends on Facebook. Okay. Or 2, concerns about the unintended release of evidence, which objectively had no effect on the lawyer's ongoing effective representation of Rick. A Sixth Amendment interference with counsel claim is at its zenith when a trial court dismisses a lawyer because it disagrees with competent advocacy. That is precisely what occurred here. Once attorneys Rosie and Baldwin were appointed and became Rick's counsel, the court lacked any authority to obstruct and sever that relationship. If the court found their conduct upsetting or negligent, it should have clearly articulated that evidence on the record and exhausted other possible remedies before removing them from the case, such as censure, disciplinary referral, or contempt proceedings. She has an absolute duty to refrain from obstructing and severing the relationship, especially where attorneys Baldwin and Rosie suggested a remedy in the event the court was considering removal. Okay. This court should grant emergency relief and reinstate attorneys Rosie and Baldwin. But reinstatement of Rick's counsel of choice is not sufficient to remedy the violation here. Rick was pursuing a speedy trial and third-party guilt strategy. He intended to file a speedy trial request in early November, but the judge kicked them out of the case, rejected their appearance, and struck their pleadings. This court is the only court in the state that can order a speedy trial date. If it does not seize this opportunity now, it will forever be lost. There is no post-judgment remedy available. The new lawyers have already indicated they will not be prepared for a speedy trial. No. I do not believe that another year in a maximum security prison, when he's already spent a year there, isn't the definition, anybody's definition, of a speedy trial. And he's not waived his right to a speedy trial. So where are we now? Right, well, okay. A new judge should be appointed to avoid the appearance of bias that will otherwise permeate these proceedings. It's already permeated. It's already a done thing. A judge shall disqualify herself in any proceedings in which the judge's impartiality might reasonably be questioned, including circumstances where the judge has a personal bias or prejudice concerning a party or a party's lawyer, or personal knowledge of facts that are in dispute of the proceedings. The commentary to this canon provides that under the rule, a judge is disqualified whenever the judge's impartiality might reasonably be questioned, regardless of whether any of the specific provisions of paragraphs 1 through 6 apply. So whatever references those are. Okay. Yeah, delayed to create more evidence. Yeah, to create more evidence. Yeah. Absolutely appalling. Appalling. And the fact that they won't even let Rosie and Baldwin have the transcript from the in-chambers meeting. The very fact that she won't give them the transcript, the court reporter denied them the transcript, that she's just disregarded all of the filings, just disregarded them, just I don't know, thrown them away. This is wrong. This is so wrong. So wrong. Here, the judge summarily found that counsel were grossly negligent and publicly proclaimed that she had grave concerns about their representation. The judge also emphatically stated she could not allow them to remain as Rick's counsel, given her concerns about the representation. So she's expressed an opinion. She's biased. Regardless of what else she's done, she's now expressed an opinion. She's biased. She has to go. She has to go. Okay. For many Hoosiers, This case marks the first time they will have followed the workings of an Indiana court. Yet, for all rulings going forward, the public will question the judge's impartiality. Yeah. What do you think about this, Slick Nick? She'll say. Okay. To restore the public's trust in the integrity of the judicial process in this high-profile case, a new special judge should be appointed. Okay. Conclusion. To ensure that going forward, Richard Allen receives his fundamental right to counsel, a writ of mandamus is appropriate to reinstate attorneys Baldwin and Rosie as court-appointed counsel, to set a trial date within 70 days from the issuance of the writ, and to remove the special judge and appoint a new one. Boom! There you go. Respectfully submitted, Mark Lehman from Logansport, Indiana, and Cara Wernicke from Brooklyn, Indiana. So Cara is active on Twitter, I've noticed. If you want to give her a follow, don't know about this dude here. Yeah, so trial date within 70 days from the issuance of the writ. 70 days. Exactly. That is how you fight for your client. There you go. So trial date within 70 days. So what's that? 2 months? So January. So essentially, when he should have been going to trial or thereabouts within a few days, I haven't worked it out. Demand justice, yes. Demand justice. If you believe Richard Allen is guilty of the murders of Abigail Williams and Liberty German, you have the need, the necessity to demand justice for Abby and Libby. Nothing else is good enough. And justice for Abby and Libby means that Richard Allen should have a fair trial, be convicted by a jury of his peers, and he goes to prison. And the families can have the closure, at least, that it will be 7 years by the time this gets to trial, even if it goes in January. By the time it's done and dusted, it's going to be 7 years. Don't you think that they deserve this to a chapter, a horrific chapter in their lives, to have an ending? I mean, look, you know, and if you believe he's innocent, well, he's in no safer hands than Baldwin and Rosie. He's got the very best chance to be acquitted. So it doesn't matter at this stage. I'll go back to the question I was asked right at the beginning of this live. Do I believe he's innocent or guilty? It doesn't matter what I believe. Which way you believe, it's your choice, your opinion. None of us knows. And the only way we're going to get a resolution legally is when this goes to trial under the rules and the fairness that should be afforded everybody. And Richard Allen has a fair trial that's judged by a jury of his peers, and he's either convicted beyond a reasonable doubt or he's found not guilty. There's no gray area here. There's no, oh, well, if this, if that. There's no gray area. There's no, listen. This is happening to Richard Allen right now. This is happening to Abby and Libby's families right now. Tomorrow, it could be happening to you and to your family. that you or somebody that you love or you admire, or you just the person down the road that you say hello to, that they're accused of a crime and not afforded the due process that everybody has a right to. Or it could be you that some horrific crime happens to, or a member of your family, and then you go through years and years and years of pain, and then at every turn, you know, there's a problem, and at every turn there's we don't know, and we don't have an answer. And then someone's arrested and you think, oh, right, great. This is the beginning of the justice process. I trust law enforcement. I've been working with law enforcement for years, and I trust them that they've got the right guy and that we're going to see a fair process. We're going to see justice. And then they're met with this. Come on. Come on. This isn't right. It can't be you next. Yorkshire Tea, I don't know what case you're referring to, but I can't see any other public defenders could have defended Richard Allen and advocated for his welfare better than Brad Rosie and Andrew Baldwin. If I ever was accused of a crime, whether I was guilty or not, in the state of Indiana, the first people I would ring would be Brad Rosie and Andrew Baldwin. I'd sell a kidney. I'd sell everything I own to pay for them as private attorneys. They wouldn't want my kidneys. I've got bad kidneys. They're pretty poor, in poor shape. But I do everything within my power to retain Brad Rosie and or Andrew Baldwin, or both of them. I would trust them. If I was ever accused of a crime in Indiana, I would trust them as my counsel, because I don't think Richard Allen could have had any better. But that's just my opinion. I say what I see. I say what I see. And that's what I see. All right, guys. So I did say I was going to keep it under an hour and a half to keep this watchable to people coming on for the replay. We've now just hit 2 hours, so I'm going to end it here. Let's wait and see what the next installment is. Who knows? There's probably new filings. There's probably new filings. I just can't keep up. But anyway, I'm going to go now and see. Oh, thank you, R&M. We would pull our kidneys. Oh, it's jumped a bit. Crowdfund for you to have Baldwin and Rosie too. They're incredible defense attorneys. They are. You know them personally. They're brilliant. They're fantastic. They've done so well. And they are, look, it just shows the strength of the men they are, right? You know, they were given the option to go quietly into the night, right? And they didn't. They didn't. They've put their practices, their reputations, they've staked everything on the line here. And they're fighting. And that has got to say a lot for them, for their willingness to stand up for what is just and what is right. And no, that's not Richard Allen's innocence. They obviously believe he's innocent, but it's not about that. It's about standing up for what is right and what is fair and what is due process. And that says a hell of a lot for them. It really does. Anyway, all right, I'm going to call it here. So thank you so much. Any opinion that you have is welcome here in my chat, in the comments on the replay. As long as you're respectful, that's all I require. Okay. It's only active and open and obnoxious trolls that get timed out. All right. Okay. So thank you, as always, to the mods for putting the links in the chat and all that good stuff. Thanks, for the donations. Welcome to all the new members. Go to the channel homepage, look for members, and you'll see the members tab, and you can then scroll down the videos that you can watch and the status updates and stuff like that. There's some bloopers on there of me falling in mud and Lord knows what. All right, guys. I'll see you very soon. I'll be back tomorrow with a video. Bye, guys.